Good morning. This is Tony Topacio. I'm a fourth-year law student from Philippine Law School. This video digest series is part of our course requirement in criminal law review for our preparation in next year's 2023 Justice Hernando Bar. I will greatly appreciate your comments, so please like and subscribe at the link below. The topic is about the relation of the revised penal code to special laws. Case of Padilla versus Judge Baltasar Dizon of RTC Pasay is an administrative complaint filed by the then Commissioner of Customs Alexander Padilla against respondent judge, allegedly for rendering a manifestly erroneous decision due to gross incompetence and gross ignorance of the law, involving judgment in the case of People versus Law Chi Fai, wherein the judge acquitted Law Chi Fai for the crime of smuggling foreign currency out of the country, a crime punishable under Section 6 of Central Bank Circular Number 960. The case, in which the respondent rendered a decision of acquittal, involved a tourist, Law Chi Fai, who was caught by a customs guard at the Manila International Airport while attempting to smuggle foreign currency and foreign exchange instruments out of the country. He was found carrying in his possession approximately $300,000 in various currencies. An information was filed against Law Chi Fai with the RTC of Pasay City for violation of the same central bank circular, which is committed by willfully attempting to take out of the Philippines through the mails or through international carriers, in this case the Manila International Airport, without declaring his or her currency, any amount in excess of the $3,000 limit set by law. For violating the said law, a person may be imprisoned for a minimum of 12 years to a maximum of 20 years and a fine of not less than 50,000 pesos. The issue before the court is whether the respondent judge is guilty of gross incompetence or gross ignorance of the law by acquitting Law Chi Fai. The court began by stating the general rule that a judge cannot be held to account or answer criminally, civilly, or administratively for an erroneous decision rendered by him in good faith. But in this case, the court held that yes, the respondent judge has shown gross incompetence or gross ignorance of the law in holding that to convict the accused for violation of Central Bank Circular 960, the prosecution must first establish that the accused had the criminal intent to violate the law. The court held that respondent ought to know that proof of malice or deliberate intent is not essential in offenses punished by special laws, which are mala prohibita, or those acts which normally are not wrong, but for the fact that a law forbids them. Although lack of malice or willful intent is not a valid defense in a case for violation of the said central bank law, the respondent nonetheless chose to exonerate the accused based on his defense that the foreign currency he was bringing out of the country when he was caught were brought to the Philippines by him and his alleged business associates on prior occasions, supposedly to be used for the purpose of investing in some unspecified business ventures. The court was surprised that respondent did not consider that the foreign currency and foreign currency instruments found in the possession of Law Chi Fai, amounting to $300,000, did not correspond to the foreign currency declarations presented by the accused at the trial. It did not matter to the respondent that the accused, by his own story, admitted, in effect, that he was a carrier of foreign currency for other people. The court found respondent Judge Dizon guilty of gross incompetence, gross ignorance of the law, and ordered him dismissed from the service.